Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to give an update on people's cases and what's going on. Let's start with Carrington's first. As you know, his case is in the Eastern District of New York, and his case that he removed from state to federal is this case number ending in 07775. So let's look and see what's happened here. He filed his notice of removal, and you can see here on 11/21 a remand order was issued saying, for the foregoing reasons, Kings County foreclosure proceedings under 11234/2009 is hereby remanded to the Supreme Court of the State of New York, Kings County. Alright, so basically he's asking that it get remanded back because the state court has had this case for 15 years and they shouldn't be able to remove it to federal court. But that doesn't mean that he doesn't still have his other case that's in court. As you can see right here, he has his other federal case against him. There it is. Let's take a look, run the report. Okay, this is his other case that he filed. And you can see that the summons for PHH was returned as executed on 11/12. So this case is going to keep going. Nothing wrong with this case. He's the plaintiff, they're the defendants. It's going to keep going in federal court. If anything happens in state court, Rooker-Feldman doctrine will not apply because he filed this before any final judgment happened in state court. Okay, sometimes you win, sometimes you lose, unfortunately. But he wanted to try it to see if he could do it, so I guess we learn from all these things, guys. Learn from mistakes other people make too. And if you have a case that's been ongoing as long as 15 years, trying to get it removed to federal court is about impossible. So we learn from that. So let's take a look at the next case. Let's look at Alita Chapman's case in Texas. And this is her case right here. This is her case that she removed from the eviction court to federal court with the last two digits 03344. Alita Chapman versus U.S. Bank. And as you can see, a lot's been going on here. She removed it on 9/9/24. Then she filed a motion to dismiss and a motion for sanctions on 9/25 and a memorandum of support. And then they ordered discovery protocols. The other side filed an opposition motion to dismiss. Then a motion to remand was submitted by U.S. Bank. And then Alita Chapman filed a request for entry of default for them not responding to the motion for sanctions. And she filed a motion for judgment on the pleadings. And then a joint discovery case management plan was entered. And then basically the last thing that was filed on this case was a reply motion in support to remand it back to state. But she also has another case in federal court which she filed. Let's take a look at that one. It's this one here ending in 03260. Okay, in this case you can see the status. She filed, well, the other side filed a notice of removal, removing it from state to federal. And then she filed an amended complaint, first amended complaint there. The judge issued a scheduling conference. And then basically they asked for extension of time to respond to the amended complaint, which they got. Order on extension granting joint discovery case management plan. Then the other side filed a motion to dismiss and a brief in support of motion on 11/8. And then you'll see Alita Chapman filed a response in opposition to their motion and a memorandum of law in support of that as well. So last thing on here, a report of a Rule 26F planning meeting by U.S. Bank was filed on 11/19. Okay guys, the next case we're going to look at is Marlon Lewis, and he's also in the same court as Alita Chapman in Texas. And his case is, let's see here, what's his case number? Here it is, 424CV02727. Okay, so they removed his case from state to federal court, as you can see, on July of 2024. And you can see what's happened since then. They've ordered a initial pretrial scheduling order, motion for entry of default, which he didn't get, because they didn't answer in time, but then they did file an amended answer. And then he filed a response. The judge ordered denying his requesting default. And then a joint discovery case management plan was submitted. Initial disclosures was submitted. Certificate of interested parties was submitted. And then the other side did the same thing. Initial disclosures, joint discovery case management, and consent. So it's going to end up going to trial. The last thing that was filed was 11/21, which was consent to proceed before a magistrate judge. So his case is basically waiting to go through the discovery phase. Okay, the next case we're going to look at is Sabrina Kohler's case. As you can see, her case number is right here, 424CV01020. She filed her complaint on 7/25/24. The summons was returned as executed. Entry of appearance by the other side. Full consent to a magistrate judge. Then she filed an amended complaint. They filed a motion to dismiss. Order on motion to dismiss. Basically told them that that she could file a amended complaint. So she filed her amended complaint. Then they filed another motion to dismiss and memorandum in support of the motion to dismiss, and then she filed a memorandum in opposition to their motion to dismiss. And that was back on September 5th. So basically it's been stagnant and waiting for the judge to rule on the motion to dismiss since 9/13/24. So we're just, it's in a holding pattern, waiting for the judge to rule on this. Okay, the next case we're going to look at is Tammy's case, Tammy Lord versus PHH Mortgage, right here. That's a case number 124CV00160. She filed her complaint against them June of 2024, June 3rd. Summons came back executed on June 12th. They answered it on 7/2/24. Notice of attorney appearance. The fact of the matter is she started pro se, but then she got an attorney. So an attorney's helping her with this. They have a discovery plan. They have a trial notice. She filed a motion to amend her complaint, which was approved. The other side filed a response to the motion. Order on motion to amend, amended complaint, answer to amended complaint. So the last thing that was filed was the other side filed an answer to the amended complaint. And I think what they're going to do is work this out at a court, hopefully, in her favor, some kind of way. Let's hope anyway, right guys? Okay guys, that gives us an update on everyone's case that we're going over. And if anybody has any questions, you can send me a comment or an email to my email address. My email address is foreclosurehelp777@gmail.com, and it's spelled just like this, with the number 4. So I hope everybody has a blessed day, and God bless.